Good afternoon, everyone, and welcome to our second webinar in Smart & Biggar's Canadian Trademark series. Before we begin, I'd like to start with just a couple housekeeping matters. Our formal presentation will last for about 35 to 40 minutes and will be followed by an open and interactive Q&A session. However, please don't let that stop you from asking any questions at any time during the presentation. You're welcome to submit questions at any time by typing them into the Q&A panel at the bottom of your screen. But we ask that you please do not type any questions into the chat panel. We will try to address as many questions as we can during our live session or in a follow-up email after today's session. Today's webinar will be recorded, and following the presentation, we will circulate an email with a replay link together with a PDF copy of the slides from our presentation. At the end of our webinar, a link will pop up asking you to complete a survey. We would appreciate it if you could take a few minutes to complete the survey and provide us with your feedback. And with that, let's get started. This is Trademarks Between Friends: Key Differences in Canadian and U.S. Trademark Practice. So joining me today is my partner from Montreal, Christian Balduc, and I am based out of our Toronto office. Both of us are partners in the Trademarks group here at Smart & Biggar, and we very much look forward to sharing with you our thoughts on some of the key differences between U.S. and Canadian trademark law. A little bit about who we are. Smart & Biggar is Canada's leading IP law firm with expertise at the interface of technology and business law. We offer our clients expertise in all areas of IP, and we are one of Canada's oldest IP firms with over 130 years serving clients, 100 plus lawyers, agents, and technical consultants across our 5 offices in Canada. We file 8,000 and more patent and trademark applications annually and offer an unparalleled litigation bench strength and record of client success. You can learn more about our firm at smartbiggar.ca. Turning now to the outline of today's presentation, we'll take you through it very quickly. We'll be discussing trademark registrations, the trademark application process in both Canada and the U.S., opposition proceedings in both Canada and the U.S., what it means to maintain a registration, expungement for failure to use, and a particularly Canadian quirk of trademark law, official marks. So turning now to trademark registrations. So in Canada, we have only one register. It's the equivalent of the U.S. principal register. There is no supplemental register. And as a result, an inherently non-distinctive mark cannot be registered until it has acquired a certain level of distinctiveness or secondary meaning through extensive use in Canada. Without a supplemental register, there's no other register on which you can park that mark until it obtains the requisite level of distinctiveness. We have no provincial trademark registers. And in the US, on the other hand, we have a national register available to all applicants involved in interstate commerce, that being the principal register, and the supplemental register, which is available for arguably descriptive marks. There's also the state register, which offers registrant state by state trademark rights. We have nothing of the sort in Canada, offering rather one federal register covering all of Canada. Upon registration in Canada, your rights extend to the entire country, unless they are expressly limited geographically. And Christian will touch upon that in his part of the presentation. Proof of acquired distinctiveness is required in all areas of the country. Where it cannot be demonstrated, the registration will be narrowed accordingly. A registration in Canada also offers negative rights. A registrant can enforce its registered rights against all infringers unless its registration is invalidated. Now, in Canada, that will be subject to change in the next little while, as currently no use is required in the first 3 years of a registration in order to enforce the registered rights granted thereby. There is currently legislation tabled in Canadian Parliament to change that, which would require a registrant to demonstrate use of a mark that had been registered within the last 3 years in order to obtain any relief based on those registered rights. Now, what happens when a registration is invalidated or challenged on the basis of invalidity? In Canada, a registration can be invalidated in a number of ways. A challenger may suggest that the trademark was not registrable at the date of registration. The trademark is not distinctive at the time proceedings bringing the validity of the registration into question are commenced. The trademark has perhaps been abandoned, or perhaps the challenger is the prior user and can so demonstrate. And then finally, if the challenger can demonstrate that the application for registration was filed in bad faith in the first place, the registration will be ruled invalid. In the US, it's slightly different in that rights extend to the entire country, except where prior rights exist, such that there's something of a vacuum or void that a registration would fill in the absence of prior rights. So those registered rights can be enforced against all infringers except those with demonstrable prior rights. And in the US, use is required in order to enforce those rights. Currently, and subject to the change in the law that will be coming up likely in the next few months, use is not presently required to enforce rights in Canada. So what does a trademark registration gets you? It gets you positive rights, title in the mark itself, the right to use, and a defense against third parties' rights and claims. A valid trademark registration is a complete defense to claims of trademark infringement and, as our Federal Court of Appeal has recently reaffirmed, passing off. So where a plaintiff comes after you for using your mark and you can demonstrate that you are completely within your rights granted by your registration and that you're using the mark as registered in Canada in connection with the goods and services covered off by the registration, it serves as a complete defense. Similarly, in the US, a registration is evidence of title in the mark itself, gives rise to a rebuttable presumption of the right to use, and can also serve as a defense against third-party rights and claims, except where prior rights exist.
So, Graham, we have a question from the audience. Somebody's asking, with this table legislation, will that mean that you're going to start again to show use to obtain a registration during the application process?
So the answer is no. Use would only be required for the purpose of enforcing that mark. And the I guess, window, that 3-year period runs from the date of registration. If you're relying on a registration that is 4 years old, you'd need not demonstrate or prove use. But it's really only within that early 3-year window. If you seek to rely on those registered rights and enforce them against another, you need to demonstrate that the mark is in fact in use.
And my understanding is it's perhaps not yet very clear the extent of the use that will have to be demonstrated for purposes of enforcement.
That's absolutely right. And it's also not clear whether a plaintiff will need to demonstrate use of the relevant goods and services or use of any goods and services covered off by its young registration. It's still very much unclear what exactly this new amendment means for rights holders in Canada. Turning to incontestability, in Canada, it's a creature of statute. It's automatic. It arises 5 years from registration. And what it does is narrows slightly the grounds on which one may seek an invalidation of a registration. As we covered off earlier, there are a number of grounds on which you can seek to invalidate a registration. After 5 years, however, it's not possible to expunge on the ground of prior use or making known unless the applicant can demonstrate that the registrant knew of the applicant's prior use and went ahead and sought to register the mark anyway. As you can well imagine, that's a difficult test to meet. In the U.S., incontestability requires proof of continued use for 5 years without any validity challenge. And if and when you file that Section 8 and 15 declaration, your rights are strengthened somewhat. Your registration is no longer susceptible to expungement on the basis of lack of distinctiveness. There's a deemed validity and rightful ownership to the registration as well.
So can you explain perhaps, Graham, the concept of making known? Because my understanding is it's not necessarily what those words mean in common parlance.
So making known is another unusual creature of Canadian trademark law. Making known is defined in the Trademarks Act and refers to other ways in which a mark becomes known to consumers, whether that's through spillover advertisements, radio play, television advertisements. It's a means of acquiring goodwill. It's a means of acquiring common law rights. And it can also serve as the basis for a challenge if a challenger can demonstrate that while its mark wasn't necessarily used in the normal course of trade as defined under the Act, it was nevertheless made known to consumers by way of these other channels, other means.
I guess that's my turn, talking about the application process.
Go for it.
Thank you. We're above 100 attendees now, so this is good. As most of you probably know, 3 years ago, almost 3 years ago, Canada abolished the filing bases for applying for a trademark application. So that means that in practice, it's quite different now than in the U.S., where filing bases are still required. However, that being said, technically speaking, use or intent to use are still required, although they don't need to be stated in the application, because the lack of use or intent to use of an applicant could be the basis of an opposition proceeding down the road if the application is published for opposition purposes. So in the US, the filing bases are similar to what they used to be in Canada: intent to use, use. There's the registration in the home country, which is, something quite unique perhaps to the US, and there's the Madrid filing bases. As in Canada, use or intent to use are also required. Classification in Canada is very much in line with that of WIPO. US can be slightly different. And I tend to find that the American system is often more practical than perhaps the one at WIPO, but that's just me saying that. Another unique creature of Canada, because there's a couple we're going to be discussing today, is that in Canada, you can open an existing registration and file in it an application. It's going to look exactly like a regular application, except that at the end of the process, whatever was covered by the application that is approved will be dumped into the existing registration that retains its original renewal date. So you're going to ask, what about proceedings for expungement on the basis of non-use. If you initiate those proceedings more than 3 years after the original date of registration, is it going to affect the new goods or services that you've integrated into the application less than 3 years? The answer is no. So you need to be very careful when you look at a registration that you're potentially contemplating to expunge in identifying whether some of the goods and services were added post original registration. So that's something to keep in mind. Now, going back to this topic of specificity, and don't worry, Graham, I was not going to forget that, that you're for sure very familiar with, because it's one of our biggest issues in this country. The level of specificity is probably the greatest that anybody has ever encountered in any trademarks office. And it causes a lot of grief. We understand and we know that the trademarks office is trying as much as possible to increase the number of accepted terms and expression in the manual of goods services to make things easier on applicant, and also they're working or planning to work with the Americans and other major trademarks office to align their practices together so that it makes filing in Canada less burdensome. And so I'm kindly reminded to remind you that if you do have questions, please do not hesitate to do so using the Q&A box. Now, the examination process in Canada, I was hearing the Americans complaining earlier this year that it has gone from 6 months to 9 to 12 months. While in Canada, it's 3.5 years right now. So sorry, but we're the worst. And in fact, we're probably the worst of the entire globe right now. I'm sure some of you have had experiences in some countries where it was pretty bad, but right now it is. The office is taking measures to address that. One of those measures is that if you pick the goods and services from the manual, it will reduce the time to examination to below 2 years. In the case of Madrid filings, well, they're examined right now under 18 months. They have no choice. And you also have the potential option of expedited examination if you fit one of the scenarios: contemplating litigation, enforcement in online marketplaces, combating counterfeiting. Those are the options that are most likely to apply to anybody attending this webinar right now. As Graham has mentioned earlier, in Canada, very much like in the US, if you want to put your mark on our register or on the principal register in the US, and your trademark is considered to be descriptive or to lack inherent distinctiveness, you have to show acquired distinctiveness. In Canada, it has to be done at the filing date of the application. The way you do this in Canada is very, very similar. It's identical to the way you do it in the US, with differences that we're going to be discussing in a few seconds. But essentially, you present your evidence by way of affidavit. Typically, it's done with a master affidavit from a representative of the applicant. You may complement this evidence with supplemental affidavits from people in the industry across the country. And the geographic scope is very important here, as Graham has discussed earlier. You have to show acquired distinctiveness across the entire country. So your evidence is going to have to explain the, I would say, split in sales and advertisement from province to province, or from section of the country to section of the country. Otherwise, you risk having a registration slimmed down to only a portion of the country. Now, very much like those registration that you can reopen and expand, you can have registrations in Canada that are going to be limited to just a few provinces. And that's something that you have to be very mindful of, because you can think that you don't have the right to use a trademark in a certain area, well, in Canada as a whole, because there's a registration. Well, if it's limited to Quebec and Ontario, technically, unless there are common law rights elsewhere in the country, you can use your mark in the 8 other provinces. So that's something quite unique to Canada that does not exist in the US. Of course, as Graham mentioned, you have the supplemental register where you can park your mark that is used until it does acquire enough distinctiveness that you can move it to the principal register. There's also this 5-year prima facie evidence of acquired distinctiveness that we don't have in Canada. So those are some of the key differences between the two systems. But as you see, there's many similarities, but there are also important differences. So in the US, a registration cannot be on the record limited geographically. It will be limited because of the existence of prior rights, but that's not shown on the register anywhere. And that's why, in a way, the US system can be a bit tricky. So oftentimes owners of federal registration in the US are going to think they can use their mark across the entire system, across the entire country, while they can be up for a pretty bad surprise if they land in a state where somebody has prior rights and they're sued for trademark infringement. So that would not happen in Canada. So those are the important differences. In terms of the examination, extensions of time are available in Canada when substantial objections are raised. When what we mean by that is prior application or registration are cited, an attack on the distinctiveness, the descriptiveness, name or surname. Those are the type of objections that will, excuse the applicant and permit an extension of time. This is not available in the US. In Canada, and as I said earlier, the Americans are very practical. So if a US examiner cites an application, they suspend the application until this application either matures to registration or not, and then resume examination. In Canada, if that happens, well, you have to oppose the application if you feel that you have a basis for opposing it. And then for your application, you're going to have to request a series of extensions of time until the potential opposition, for example, is resolved hopefully in your favor. Another thing that is quite important to understand is that consent agreements in the US bear a lot of weight. And the way we prepare them in Canada is exactly identical to the way they're being prepared in the US. So you explain why the marks can coexist peacefully, the channels, the consumers are different, the goods are different, and so on and so forth. We do exactly the same thing, but the outcome is not the same oftentimes because examiners have entire discretion. And so at the end of the day, they have very limited weight in Canada, except in cases where this consent agreement is going to educate the examiner enough that the examiner is going to understand that the two parties are in different industries and that the goods and services do not overlap. And sometimes that's not obvious. I remember doing one years ago where one client was selling tools, the kind of tools that you buy in a hardware shop at $500, whereas the other one was doing machine tools selling at $100,000 plus. Not really the same type of goods that we're selling here, but the examiner didn't understand until we filed a consent agreement. In Canada, disclaimers are not required, but they are recognized, except for cases such as if somebody integrates the flag that you see there in their trademark, and in the US, they are required.
Christian, a quick
Yep.
question for can goods in an already filed application be amended to conform to CIPO's pre-approved list and thus receive expedited examination? Or did,
Absolutely, they can. And in fact, there's a program ongoing right now whereby SIPO is identifying these cases using an automated system with AI, and they're dispatching letters to agents in Canada, and agents will, in the near future, be corresponding with applicants that have application covering such goods and services that could be amended to match those in the goods and services manual, so that the delay to examination is potentially reduced by more than 1.5 years. So absolutely. And I believe that's lastly, in Canada, once you reach the end of the process, no declaration of use, no registration fee, no specimens of use. Whereas in the US, you may have to show use if the application was filed on intent to use. If you do so, you also have to pay a fee for each class covered by the application. In the US, there's no registration fee, but the specimens of use are required. Turning back to you, Graham, for opposition proceedings.
thanks, Christian. So in Canada, oppositions occur by way of a relatively summary proceeding. They tend to be less expensive than the much more complex procedures in place in the US. And in particular, the deposition process is considerably more restricted in Canada. In Canada, a proceeding is commenced by way of a statement of opposition, which sets out the grounds of opposition. You don't need to file an evidentiary brief or concise statement of facts with this pleading. It simply sets out the statutory grounds on which you're relying to oppose the application. The evidence and written submissions, those come much later in the process. Now, when it comes time to filing your evidence, there's no documentary or oral discovery in an opposition proceeding. Rather, parties submit affidavit evidence. The parties are then most often cross-examined thereon. And the cross-examination itself is quite narrow. It's typically bound to the four corners of the affidavit and confined to the grounds of opposition pled. So as a result, things are typically quite narrow compared to the deposition process in the US. As you'll see along the side of the slide there are certain steps with an asterisk. Those steps are optional. So you could very well have a case where an opposition proceeds entirely on the pleadings alone, the statement of opposition and the applicant's counterstatement. Now, it's theoretically possible, it's not recommended, but it could be done. The statement of opposition frames the entire proceeding. It has to set out everything on which you intend to rely in terms of grounds. Subject to seeking leave to amend, the hearing officer at the end of the day will not consider anything that is outside the statement of opposition. We have requests for interlocutory ruling. If an applicant receives a statement of opposition and believes that it's baseless, there are simply no valid grounds of opposition, it can request that the registrar make an interlocutory ruling to strike entirely or narrow the statement of opposition. Then we have the counterstatement, which until about 3 years ago when the law changed was a substantive reply. Now, under the new Canadian trademarks law, the counterstatement is a single sentence that the applicant intends to respond to the opposition. In terms of evidence, the opponent has to put in its case first. The applicant then has an opportunity to cross-examine thereon before providing its own evidence. And then the opponent, of course, has an opportunity to cross-examine the applicant's evidence before putting in any reply evidence. Once the evidentiary process is closed, the parties have an opportunity to file written arguments and subsequently request an oral hearing. And consistent with the long periods of time in the examination process, the Trademarks Opposition Board is also quite slow at present. Right now, the timing from requesting an oral hearing to actually having the matter heard is about 2 years. So there's a lot of waiting involved. In the U.S., the process is akin to litigation. It's very involved, it's very expensive, it's very complex, and it's also typically shorter than the process in Canada. So we're often asked, what does it mean to withdraw an opposition? Well, withdrawing your opposition in Canada does not prejudice your rights to object to the applicant's use of the mark or even seek subsequent expungement of the mark in our federal court. Once the mark is registered, you are nevertheless within your rights to seek its expungement for invalidity before the court, even if you did initially oppose and subsequently withdraw the opposition to the application. In the US, it's a bit different. Withdrawing your opposition may prejudice your rights to object to the applicant's use of the mark down the road, and that can have, of course, negative consequences. We're often asked if default judgment is available in Canadian opposition proceedings. It is available, but unlike in the US, it's automatic. If an applicant fails to file an answer or a counterstatement, then the application is simply deemed abandoned, and the whole thing will fall away in due course. Similarly, if either party fails to file evidence or a statement that it does not wish to file evidence, then the proceeding will be deemed concluded. If the opponent does not file evidence or a statement that it does not wish to file evidence, then the opposition is deemed withdrawn. And if the applicant fails to file evidence or a statement that it does not wish to file evidence, the application will be deemed abandoned. As I mentioned, the time frame in Canada is quite long. There are many extensions of time available to each party at each stage. And so things can be drawn out over 5, 6+ years. And it's relatively inexpensive compared to the US, 50,000 to 100,000 Canadian dollars over the course of those 5-6 years. And again, that's dependent on the steps taken in the opposition proceeding. In the US, I've seen some bills from opposition proceedings. They are not cheap. They can get very expensive very quickly, largely on account of the steps in the proceeding itself, as well as the typical complexity of the proceeding.
Graham, what about oppositions involving Madrid filings? Are they any different? Are there any things that you need to watch for?
Absolutely. And in fact, the one thing you will absolutely need to watch for is the period of time within which you can oppose a protocol application. You only get one 4-month time extension in Canada. That's it. If you request that extension and you do not you don't oppose in time, you're not entitled to any further extensions. Whereas, as I mentioned, for a national application, there are a multitude of time extensions available, including a 4-month benchmark extension to oppose an application, plus an additional cooling off period of up to 9 months, but only with the applicant's consent.
Great, thanks. We must be doing a great job because there are not many questions coming in, so good show. We'll talk about maintenance now. All right, so in Canada, it's all about simplicity in a way, because there's no maintenance required in the first 10 years. Renewal is you just pay a fee, no statement of use required. And in the case of old registrations, pre-2019, you're going to have to integrate the NIS classification to your registration in order to renew it and pay a fee per class. In the US, there's this maintenance between the 5th and 6th anniversary from the date of registration that requires you to show that you are using the mark with the goods and services covered by the registration. And then 4 years later at renewal, the first renewal, you still have to show use. And each time, specimens of use, 1 per class, are required. Now, these statements of use say basically that if you lie, you go to prison, but I understand that that has yet to happen. At least that's the information that I received thus far. So the simplicity with which you can maintain a registration in the US explains why what Graham is going to talk about in 2 minutes is equally simple compared to the US, where maintaining is burdensome and aims at verifying that there is use of the mark, whereas expunging it can be a bit more challenging. So now moving on to expungement for failure to use.
Great, thank you, Christian. So this is a really interesting area of law in both countries, and I think for reasons that will become obvious, it's become even more interesting in the US over the last year. So prior to joining Smart & Biggar, I worked at the Trademarks Opposition Board, actually drafting Section 45 cancellation decisions. So this is an area that's of particular interest to me. In Canada, this is the way things happen. So anyone can request that a registration that's 3 years or older be challenged for non-use. That person does not have to have any interest whatsoever in the mark. He or she does not have to have a mark on the register awaiting examination. It can be anyone. In fact, the registrar himself can also now commence these proceedings. The request itself can be in respect of all the goods and services covered in the registration, or maybe just a few. And so you can use that request strategically where, for example, your application is in examination, the examiner has cited an old registration against your application, but the objection really only applies to a few goods and services. Once you've made that request, the registrar sends along a notice to the registrant, and the registrant then has an initial period of 3 months that's extendable by a further 4 months to file evidence of use. If the registrant doesn't do a thing, doesn't file anything, then the registration will in due course be struck in its entirety from the register. Now, one thing to note, there's no cross-examination on evidence of use in Section 45 proceedings in Section 45 proceedings. There's also the option to file written arguments once the evidence is in and request an oral hearing. So these things are typically inter partes. They're ex parte if you send a request and it simply is off into the abyss. The registrant doesn't respond. In that case, it's pretty much ex parte, and the registration is struck in due course. So one thing to bear in mind in Canada, these processes are very simple. They're summary in nature. They're meant to be very quick and straightforward. There is no initial evidentiary burden on the requesting party in Canada. They need only file a request and pay a government fee of about 400 Canadian dollars. The requesting party doesn't need to share the results of any prior investigation, for example, nor is there any need to provide a concise statement of facts. In Canada, these are very one-sided affairs for the most part. Much of the burden is on the registrant to prove use, and so they can be used strategically to put added pressure on an opponent, for example, or a plaintiff in concurrent proceedings. Now, turning to the US, we of course have the expungement action before the TTAB in the regular course, which is akin to litigation. Like an opposition proceeding, it's long, it's complex, it's expensive. And now with the coming into force of the Trademark Modernization Act, we have now 2 new tools made available to clean up the register. And I think these are particularly exciting. With ex parte expungement, we can petition for expungement of a mark, provided that the petition is filed between 3 and 10 years after the date of registration. Now that's except up until the end of 2023, any registration that is at least 3 years old may be subject to expungement. And a petition for expungement must be accompanied by the required fee of $400 per class, a concise statement of relevant facts, along with a verified statement that a reasonable investigation was completed and supporting evidence of that investigation. I know in speaking with colleagues at the annual meeting earlier this month, this is still very much new ground, new territory. And so I understand that many U.S. associates are watching very carefully to see, what constitutes the initial evidentiary burden, how much evidence is enough to persuade the registrar, or rather the director of the USPTO, to issue the request for evidence of use. And then we also have ex parte reexamination, which is something that's very unique. There's nothing like it in Canada, where a third party or the director of the USPTO can institute reexamination to challenge a registration based on evidence that the mark was not in use in commerce in connection with some or all of the goods, either at the filing date of the application, where the applicant amended its application to allege use, or before the filing deadline for a statement of use. And a reexamination proceeding must be filed within the first 5 years of registration. As I mentioned, I find the reexamination interesting because it is unique to the US. In a way, it's like an invalidation proceeding that we might bring in Canada before a court, because you're challenging an applicant's declaration or evidence at the time of filing, essentially claiming that the application was filed in bad faith. And it could be helpful where a mark could not possibly have been in use at the time of filing, or in some cases, the specimens of use may appear doctored.
So a question for you, Graham. This difference about the Canadian process, does that give rise to a certain practice by firms in Canada?
It does. It does, in fact, Christian.
And then what's the purpose of that?
So it's not uncommon to see law firms commence these cancellation proceedings in Canada, and they'll do so on behalf of their client. The reason the firms will commence the expungement proceeding is because they want to conceal the identity of their client, whoever it is that would ultimately benefit from the cancellation of the registration in question. And so typically what happens is a firm will file the request itself. The firm will be the party for all intents and purposes to the proceeding. And it's really a means of concealing the client's identity. Now, that said, it's pretty easy most often to discern who exactly has a vested interest in the cancellation of the registration. Oftentimes, it's an applicant whose application is waiting in examination, subject to the cancellation of a cited registration. So if you do a bit of digging, you can usually find out who's behind the party.
All right, so we have another question, Graham. Someone is asking how likely the Canadian registrar is to initiate such an expungement proceeding on its own.
So we've had this option for about 3 years now. To my knowledge, it hasn't happened yet. When it first became available, when it was first an option, there was some speculation that the registrar would be targeting these massive 45 class applications that proceed to registration. But in my experience, I have yet to see the registrar, in fact, commence a cancellation proceeding on his own.
Thanks. I have a question that's actually directed, I believe, at me. Someone is asking, in the U.S., when you have to show evidence of use, what is that evidence of use? So typically the evidence of use is going to be, for example, if we're talking about goods, picture of the goods, and a statement that you've been selling these goods in the U.S. market at the time of the declaration. It could be a variety of other things. It could be a hang tag for services. It could be a picture showing that the services are being performed. with the statement that they're being performed in the U.S. at the time of the declaration. They can take a number of form, but you don't actually have to ship any of the actual goods to the trademarks office. I believe, like way before I started practicing in Canada, there was something similar to something of that nature in Canada, but that was a long time ago, if it ever existed.
So just looking at the overall differences between expungement proceedings in Canada and the U.S., to recap, anyone can commence a proceeding, even the registrar in Canada. In the U.S., it's an interested party. The outcome is the same in both cases. A registration may be maintained, it may be narrowed somewhat, or it may be expunged altogether. And the time frame in Canada will really depend on whether any evidence of use is in fact filed. If it is, and it goes to a full-blown hearing, I mean, you can expect an expungement proceeding to take up to 5 years. If it isn't, if the registrant is silent, well, the registration will be deemed expunged in due course. And in that case, you're looking at a very inexpensive proceeding. Really, the only costs incurred by the requesting party are the costs of filing the request at first instance. Now, these decisions are appealable. They can be appealed to our federal court, and additional evidence may be filed by only the registrant on appeal. So the registrant has a second kick at the can, so to speak. If it seeks to appeal an unfavorable decision, it can file further evidence of use on appeal, but still there is no cross-examination on that evidence. Again, in the US, a bit of a different story. Time frame, a bit shorter, and as we've come to understand, much more expensive.
So somebody's asking for the costs. It's on the slide. Obviously, if all you do is you pay for the notice to be issued, not going to be too expensive. So I think that's taken care of, right?
Yeah.
All right, thank you, Graham. So I guess that's me talking now about another Canadian particularity, which is our official mark system. So these creatures of Canadian law do not have their exact counterpart in the U.S. I know that flags and national emblems can be protected in the U.S., but not the way we're discussing here. Here in Canada, if you are a public authority, which is the Majesty's forces, government, federal, provincial, or municipal, or entities that are, I would say, similar to those would qualify as public authority. They have to show that they are a public authority, and if they are, they can request the publication of a mark that they have adopted. And adopting a mark for an official mark doesn't mean necessarily using it as a regular trademark. It could be simply displaying it on a website, and that does the job. And then the mark is published. It never becomes registered. It's published. It stays there forever unless the public authority asks that it be withdrawn, or if it's challenged in court. And the only challenge that could take place is that it was not a public authority, or that it's no longer a public authority, which is possible. I mean, some public authorities in Canada at one point or another in their life have sometimes been privatized and are no longer public authorities. There's no case law on that, but that could be potentially something that could be the basis of a challenge. So that's something perhaps interesting. Now, once it's published, it's a prohibition. Now, what does that mean, a prohibition? It means that nobody can adopt in Canada a trademark that is identical or so nearly resembling as to be mistaken for, that's the actual language, for the official mark for any types of goods and services. Now, contrary to regular trademark, if you seek the consent of the public authority or the university, because I haven't spoken about university, but a university can also request the publication of an official mark. If you ask the consent, it's a simple consent that just says, I consent to the use, their application, and the registration of this mark for these people, this applicant, for the goods and services covered by the application. And that's sufficient to overcome the citation of the official mark.
Christian, if I may.
Yes.
I've had a few cases where an official mark has been cited against a client's application, and it's not uncommon for those public authorities or even universities to request, in exchange for written consent, a small donation.
Yes, and I've encountered that as well. I would say that it happened to me only once in these past 27 years, but I've heard of that, and it happened to me once. It's not necessarily something that's too common. And I would say that in my experience, and I don't know about yours, typically, unless you're in an industry that could bring, I would say, bad reputation to the public authority, they're typically willing to consent, perhaps sometimes in exchange for some administrative fee,
Yeah.
perhaps sometimes more abusive than that, who knows. The difference between the public authority and the university is important to understand. The public authority has to be in Canada, whereas the university itself can be anywhere in the world. So as I said, this creature, once it's published, it's there, it sits there, there's no renewal, no maintenance, no nothing, and it will remain there forever unless the law is potentially changed down the road. So process and maintenance, fairly simple.
Christian, we have a couple questions here from the audience. First, can you license an official mark?
That is such a great question. And, you know, my answer might not please some people, but how can you license a prohibition? So that would be my answer. However, the mark that is the subject of the prohibition is a trademark, oftentimes, either for the public authority or for the university, that is actually used as a trademark. And so if there is such a trademark underneath the official mark, such trademark can be licensed. The official mark, there is some case law out there. I believe there's a case that says yes, and there's a case that says no. I have read both cases. I think that, in my humble opinion, they're not necessarily based on the right principles. At the end of the day, maybe not the right questions were asked, but if you go back to the concept of what an official mark is, i.e. a prohibition, it's not a property right, it's a stop sign. But underneath there is a property, and it's the trademark that is used perhaps by the official mark itself, by the public authority itself, or under license by some third party, or by the university directly, or licensed to third party to manufacture the kind of widgets that a university can sell to its student or to people in general. So that would be my answer to that question.
Thanks, Christian. And do you see public authorities enforcing their advertised marks, or are they used more defensively by public authorities?
So in my experience, I've seen public authorities enforce their rights, and well, they've enforced the actual prohibition. Oftentimes, those who take on official marks or have official marks published are going to have regular trademarks registered as well, especially if they're exploited commercially. But yes, there are public authorities and universities that do enforce this prohibition against third parties.
And now, what if you're a trader in the normal course operating in Canada, and you've been using a particular mark, and along comes a public authority that requests the advertisement of its own official mark, and suddenly there's a prohibition in place?
So that's a great question. So the way it works, and I haven't covered that, and I'm going to cover two things with your question. This is great. So when you request the publication of an official mark, it's actually only examined to determine if you're a university or a public authority. It could be conflicting with a bunch of pre-existing trademarks, either on the register or in the market. So if you are already on the register, no worries. Your mark is registered. If it's already in use with certain goods and services, no worries. The prohibition takes place the moment the publication happens. So if you want to expand your registration or expand your use post-publication of the official mark, then you would have to seek the consent of the public authority. So that would be the solution to that. So of course, it's happened many, many times that universities have published official marks that correspond to major brands. And I know of a couple. And so each time those brand owners want to expand the portfolio, they need to turn to, for example, those Canadian universities and seek their consent to do so.
Great. Thanks, Christian.
So I guess that
brings us to our Q&A portion.
And we respected the timeline perfectly. Good job. Any other questions? Well, it looks like we've done a pretty good job. So I guess I will keep the parting note and say thank you everyone for attending our webinar. It was an absolute pleasure. If you have any question, please do not hesitate to reach out to us. We'll be delighted to answer and perhaps send you even a bill if it's substantial. Thank you very much.
Thank you. Bye-bye.
Bye-bye.